Okay, I think our stalwarts who have remained to the bitter end, we typically end with a race through or a run through of leading patent cases. Obviously, it's a pretty exciting year with 6 patent cases at the Supreme Court and the Federal Circuit assuming a woeful 0 for 6 record in them. But how much did some of them really change? Well, we'll talk about that in some leading cases from the Federal Circuit. The backgrounds of our panelists are in the brochure that we gave to each of you. I'll just briefly introduce my old friend Margot Bagley, who...
Old friend?
Yeah, well...
Really?
I think we're about the same.
Yeah.
But my long-standing friend. And actually, okay, well... Laugh it up. You know, there's an old German phrase I never really quite got, which is everything has an end, but a sausage has 2. And I don't know much about that phrase, and my German's not very good, but I think it's supposed to mean that it mitigates the harshness of, for example, a departure or something like that, right? Someone says that, like maybe we meet again or something like that. So Margot has done that. You know, she was at Emory, and then she joined the University of Virginia faculty for a decade, and now she's back at Emory. So
yes, you're right.
Okay. You know, you're further away, but more convenient in a way. Because who wants to go to the hinterlands? Quite frankly,
it's a lovely place.
We say that somewhat bitterly because when we make job offers, sometimes we lose people down to Charlottesville. So congratulations to come back home in a way. Margot's a distinguished patent scholar, I think best known for her international work, but she's involved in a lot of facets. We're really glad to have Beth Winston here. We've tried to get her over here a couple other times to Georgetown. I mean, how far? You're just right over there. But oh no, I'm going to be in Europe, or I have a speech on the West Coast. So getting her to Capitol Hill has been a struggle. It's great to have a community of patent law professors here in Washington. And I think I'm the oldest. Let's put it that way. So, anyway, and also certainly a respected patent law scholar. So, well, thanks for coming.
We'll say you are the most respected. How's
Yeah,
that?
all right. Well, speaking of respect or lack thereof, my fellow University of Michigan graduate, Jake Shurkall, is here. James Hoppenfeld is sharing some of the misery of our gridiron performance this year. Jake also has a master's degree in biotech and is I'd say he's got to be the bright young hope of law and patent law and biotechnology. I think that's where he's made his mark as a scholar. He's a member of the New York Law School faculty. And we're grateful to have a distinguished colleague join us, not a full-time faculty member, but one who's taught at area law schools for many years, Judge McKelvey. Judge McKelvey spent over a decade on the bench at the District of Delaware, and since then has been a distinguished patent litigator at Covington and Burling. He retired recently from Covington and Burling, and I thought he was going to have something of a sinecure and spend his time down at Rehoboth Beach or something like that. But in fact, we are colleagues together on the Patent Quality Initiative, along with Jerry Mossinghoff, and sort of taking a look, basically filing some IPRs. I guess that's sort of the bottom line work. So it's really been a wonderful opportunity to get to know you better professionally and work with you in that capacity. I'm really grateful you could take time out to join us here on Friday afternoon. We are just going to do a whirlwind review we chose a lucky 13 cases, but we thought we're leading lights of the last year as we do. And without too much more work, we're going to march in. I've asked each panelist to present some of the cases. And then I'm inviting each of us to weigh in. As the moderator, I'll just try to settle disputes, or if fisticuffs break out, I'll be on the scene. So, Margaret, I wonder if you could start, and I've asked you to do the impression products case first. Thank you.
So thanks so much, and a special thank you to Jay and Peter and Alex for arranging this wonderful conference and inviting me to participate. I've been delighted to be here. So the first case is Impression Products versus Lexmark. This is a case that I thought was long expected. I'd been expecting it since Quanta and certainly since Kurtzsang. But here we have the product involved, these toner cartridges, printer toner cartridges that are being recycled and are being sold in the United States and Lexmark is not very happy about this. And there are two groups of cartridges, and Lexmark had two different theories of infringement. So the first group are cartridges that were subject to a contractual single-use, no resale provision, and yet customers who were buying them at a discount and supposed to send them back were not, and Impression Products was getting a hold of them, refilling them, reselling them. Lexmark asserted that those were being infringed, the patents on those were being infringed because they had expressly prohibited their sale. And then there were cartridges that were first sold outside of the United States, and Lexmark stated that they had not authorized those to be imported into the United States. And this is a approach that had been accepted by the Federal Circuit based on its earlier precedent. So as regard to the no resale provision, the Federal Circuit relied on its Malincrot v. Metapart case law to say that patent owners could put those kinds of restrictions on the sale of products, and they were enforceable. And it's Fuji versus Jazz Photo precedent that the first sale of a product outside of the United States did not exhaust the U.S. patent right. So Impression Products was saying, nope, these products have been first sold, that exhausts the patent right wherever they are, and that was their defense. And the Supreme Court agreed with Impression Products and basically said a first sale, whether it's subject to any sort of restriction or not, exhausts the patent holder's rights. And the reasoning was based on the prohibition against restraints on alienation, largely, though the court, of course, also did talk about its recent decision in the Kurtzing versus John Wiley case, where it had decided the same issue on largely the same basis in the copyright context. And what I found particularly interesting was even though this was an expected decision, was the breadth of what we would call international exhaustion that the Supreme Court adopted. The government had proposed that the Supreme Court should take a middle ground of saying that, yes, first sale anywhere exhausts the patent rights. However, the patent owner has the right to basically reserve the rights to restrict the U.S. market. And that's actually an approach that is taken in some other countries, in particular Japan. The Supreme Court chose not to do that and just basically first sale anywhere exhausts the right. So that's the basic introduction. I don't know why you want to.
Any observations from the panelists? I'll toss out a few. First, to me, it was sort of like Myriad, the gene patent case. Why would anyone test this issue before the courts? You knew which way this was going. So it just seemed a very brazen strategy even to bring this before bring this into the judiciary. Obviously, there are a lot of former and few current congressional staff. There's been a lot of efforts to reform food and drug law to allow for so-called re-importation of patented pharmaceuticals. A big stumbling block was concern that even if food and drug law barriers were lifted, that intellectual property ones would remain. So with patents out of the picture, I don't know how much traction the proposal has in sort of a very fractured polity, but certainly there's been a lot of noise about either allowing the Secretary of Health and Human Services to authorize parallel imports, or actually to have a whole new, which is possible under current legislation, or in fact to have a more wholesale review and allow parallel importation of many jurisdictions. Other observations? Okay, let's move upward and onward. And next we have Judge McKelvey talking about a case we've heard a bit about before, T.C. Heartland and Cray.
Right, so I won't go over T.C. Heartland too much, except to say that I usually look at Federal Circuit decisions in the context of what I call the Galapagos theory, which is ever since 1982, it's been sort of isolated by itself and it's growing up some strange animals in the law, including the affirmative duty of good faith. And one of the strange animals that it grew was V.E. Holding, which is a decision that's clearly wrong, but it's been the law of venue, patent venue, since 1990. And the Supreme Court 8-0 reversed it. This is a decision that talked about where a corporation resides, and it found that the corporation resides in the state of incorporation, which is Delaware. We have Jim Dabney and John Duffy to thank again for taking up a Federal Circuit decision and getting it reversed.
Doesn't seem all that hard to do.
it is surprising that it lasted for 27 years without somebody taking it up. And I agree that it will drive patent cases to other jurisdictions, although I don't know that it's going to drive them all to Delaware. I was happy to see the statistics today on the screen about other jurisdictions getting cases. I think it could mean that jurisdictions like New York and Florida and Massachusetts will get cases now too. I may be optimistic about it, but I think it will give some defendants some opportunity to get out of the Eastern District of Texas if they want to, although we all know that there are other defendants that may not be able to get out at all. And the highlight of the decision is footnote number 1, which is, if you remember Gilda Radner from Saturday Night Live, Emily Latella, never mind. They have footnote 1 saying it's not clear that the defendant is in fact a corporation. And it was a case about where a corporation resides. So that's T.C. Heartland.
Other observations? Look, I don't have a hot bench today, but you know, I didn't attend the Eastern District of Texas bench and bar this year because I thought it might be funereal. Some had predicted prior to the VE holding case, so that's the case where the Federal Circuit equated personal jurisdiction and venue. A study I think was done by Professor Janicki, and he discovered that there were 4 patent cases filed in that district that year, 4. And so he predicted, again, there would be 4 going forward. And obviously that has not happened. So obviously ED Texas is still very much in the game, but perhaps just a little bit less so. So I was a little surprised to see that. I thought it was going to go off the map. And in fact, it still seems to be pretty active. Other observations?
Well, I also looked at Cray, which is the decision that came down a couple of weeks ago by Judge Lurie on a panel, unanimous panel for the Federal Circuit, on what is a regular and established place of business. And under my Galapagos test, this passes because the court cited other circuit courts in its decision, although you'll notice they're all pre-1990 decisions because they're the only court that didn't follow those rules after 1990. But he established the pretty precise, low flying test for determining whether or not you have caught a defendant in a place where it has a regular and established place of business. You saw the factors up on the screen earlier today. You look for the physical place in the district, you look for regular and established place of business, must be a place of the defendant. But it's a pretty good decision. It shows the Federal Circuit is getting back onto the mainland of the law.
Beth, I ask you to take a look at Allergan v. Teva.
So first of all, thank you for having me. It's a real pleasure to be here. Second of all, you've just been talking about how Eastern District of Texas, well, Allergan versus Teva goes back to the Eastern District of Texas. My favorite expression in all of patent law is one I learned from the Eastern District of Texas, that we are TBLs. Do you guys know what that is? Tall building lawyers. And that's what they call the lawyers from out of town that go and argue cases in the Eastern District of Texas. So, all right. So I'm starting my part of the panel discussion with Allergan versus Teva Pharmaceutical, which is a case that is actually of more interest for the points it does not make than for the case itself. The issue in the case is not the technology, although that's interesting to many, and I'm sure you're going to go into technology in great detail.
Oh, yeah.
Yeah, well, we're going to skim over that part. It's not the 135-page opinion issued in October of this year invalidating the patents as obvious. The issue comes down to how Allergan is seeking to avoid having the case heard at the Patent Office and in the District Court. Allergan holds 6 patents on the popular eye drop Restasis. Teva, Mylan, and other generic drug manufacturers filed applications with the FDA to approve and produce generic versions of Restasis. Allergan sued the generic drug manufacturers in the Eastern District of Texas, and Judge Bryson, sitting by designation, was assigned the case. There is no jury. The generic drug manufacturers raised defense of invalidity in the district court and filed petitions with the PTAB seeking IPR. The petitions were granted, and Allergan found itself in the unenviable and familiar position of defending itself before the Patent Office and the district court, seeking a way to, quote-unquote, strengthen the defense of its Restasis patents in the IPRs before the PTAB, actually, rather, really, to not have to defend Restasis before both the district court and the PTAB, Allergan found an unusual solution to the problem. They transferred all of the patents to the St. Regis Mohawk tribe in the state of New York to take advantage of tribal sovereign immunity. As part of the transfer, Allergan received an exclusive grant-back license to the technology. They retain all of the rights in the patent except for the tribe can continue to do some research and development, which is a little questionable as to how the St. Regis Mohawk tribe, which has not had a strong pharmaceutical practice and industry, is going to do this. They are prohibited from commercializing the patent, but they've received $13.75 million upfront and will receive $15 million a year as long as the patents are not found invalid. Both the tribe and Allergan have been explicit about why they executed the deal. They've done so to avoid having the Patent Office review their patents and to keep the review in the district court. How did they do this? Members of federally recognized Native American tribes are subject to suit only where Congress has authorized the suit or the tribe has waived its immunity. The immunity does not depend on the commercial or tribal nature of the activity. It runs with the tribe and not with the land. Furthermore, like all sovereign immunity, it can be abrogated by the tribe. But there is no record of any Native American tribe having waived patent infringement immunity. In fact, there are at least 2 district court cases in which Native American tribes have relied on sovereign immunity to avoid patent infringement charges. Once the transfer took place, Allergan then asked the Patent Office to dismiss the pending IPR for lack of jurisdiction, since the St. Regis Mohawk tribe now owns the patent and it is immune to the suit. At this point in time, to the best of my knowledge, the question of tribal sovereign immunity in this case remains pending before the board. It is one of first impression for them. In January, the Patent Office first addressed sovereign immunity, but they did so with respect to IPRs as far as state claims of sovereign immunity. Sovereign immunity in that case was a claim to state sovereign immunity made by a state university, specifically the University of Florida's Research Foundation. In that case, and 2 others since, the board has found that sovereign immunity protects state universities and their research arms from IPRs. Why is it important to distinguish between state and tribal? Because they arise from different places. Fundamentally, the 2 types of sovereign immunities differ in one very important way. State sovereign immunity arises from the 11th Amendment to the Constitution, while tribal sovereign immunity is plenary, deriving from congressional grant, meaning that what Congress gives, Congress can take away. And so tribal sovereign immunity, unlike state sovereign immunity, can be affirmatively taken away by congressional legislation. And if Congress votes to remove sovereign immunity, then the Native American tribes can be sued for infringement. Senator Claire McCaskill has already introduced a Senate bill to abrogate sovereign immunity. It's very narrowly drafted. It would simply abrogate it for IPRs. It would not even go so far as to go for covered business methods or other administrative proceedings. The St. Regis tribe is currently the assignee of over 40 other patents from SRC Labs, which is a high-performance computing company founded by Seymour Cray. Suit has been filed against Apple and Microsoft in the Eastern District of Virginia with respect to those patents. Apple is also currently defending a patent infringement suit in Delaware, where the patents have been assigned to the 3 affiliated tribes, which are the Mandan, Hidatsa, and, excuse my pronunciation, Akira tribes. There are other lawsuits in the works and other deals ongoing. Accordingly, Allergan's creative and controversial sovereign immunity strategy may prove to be successful at the PTAB, but based on this public outcry and the skepticism in federal court, Judge Bryson was very skeptical. He wrote in dicta, but he said this was a sham and that this was renting out and monetizing that tribal immunity. Tribal sovereign immunity at the PTAB may not be available for long.
So I would simply add, there are ways Congress can abrogate sovereign immunity for states, although it turns out
It's hard.
It's hard, yeah, exactly. It can be hard, and it's as, I'm not sure we'll quite get to this in my basic patents class. There is actually a piece of statutory deadwood sitting around in the Patent Act.
296.
And that cases like Florida prepaid that have been held to be sort of unenforceable. So it's not just, I don't know if this will bring a more wholesale reconsideration of sovereign immunity for state entities, et cetera, but I think it's quite frankly, it's pretty tricky to predict congressional activity. I wouldn't stake a lot on it.
It is, the focus has been on tribal sovereign immunity because of the difficulties
Yeah,
with
right.
the Constitution. It's much easier to abrogate the sovereign immunity for tribes than it is for states.
I didn't, I thought that Bryson's language was a little more impactful, but you're saying he just sort of threw shade on the deal without, sort of ruling on it? Is that the?
So there was a motion so there was a motion on the patents which found the patents invalid. Not a motion, the patents were found invalid. There was a separate motion to join the tribe in Allergan. And in the motion granting the joinder, he wrote that Allergan purports to have sold the patents to the tribe, but in reality it has paid the tribe to allow Allergan to purchase, or perhaps more precisely to rent, the tribe's sovereign immunity in order to defeat the pending IPR proceedings in the PTO,
Got it, okay,
which is pretty strong language.
indeed. Anything else? Good. Okay, Jake, who is our biotech maven, was eager, and he has 4 minutes
That's right.
to explain Amgen v. Sandoz, the biologics patent dance. Go to, my friend, you're on a timer.
So when I was growing up, there was this game show for kids called Double Dare with Mark Summers, right? The object was to win points, which contestants could do by either answering trivia questions or taking the physical challenge, essentially this obstacle course that was a cross between Rube Goldberg inventions and things from Fear Factor. Sandoz versus Amgen is such a case because it requires its combatants to make a similar choice, and because presenting this case in 3 to 5 minutes is itself a physical challenge. So, drug patent litigation in general takes place before generics have had the opportunity to actually sell their product. This is because had they waited to initiate litigation until after receiving FDA approval, this would amount to an artificial extension of the developer's patent. The patent would expire, then generics would receive FDA approval, and then, and only then, could they launch. For simple drugs, what we call small molecule drugs, this takes place under the auspices of the Hatch-Waxman Act, of which many of you here are probably familiar, frequently in a single Götterdämmerung of litigation concerning all of the pioneers' patents, if you want to take an opera analogy there. For larger molecule drugs, what we call biologics, Congress recently enacted a new regime called the Biologics Price Competition and Innovation Act, or the BPCIA. There, the belligerents are classified as either the reference sponsor, this is the pioneer, or the biosimilar manufacturer, this is the generic analog. In contrast to Hatch-Waxman cases, the BPCIA does not proceed as a single cataclysmic event, but rather in a series of exploding rounds like star death. The statute governing those rounds is a model of complexity, and I'm not embarrassed to opine, nonsense and impracticality. It is this statute that the Supreme Court was tasked to interpret. Ideally, the statute steps proceed as follows. The biosimilar files what's known as an abbreviated biologics license application, or an ABLA, with FDA. Once FDA accepts this, the biosimilar provides this application and details of its manufacturing process to the reference sponsor. The sponsor then provides a list of its patents covering its product and methods of its manufacture, the A list, after the subsection in the statute requiring it. The biosimilar then presents a list of patents it thinks the sponsor left out, the B list. The sponsor then provides its enforceability and infringement arguments, the C list. The parties are then expected to agree, I don't know how this actually happens in reality, on which patents they would like to litigate first and which they would like to litigate later after the FDA approves the biosimilar product. Invoking David Attenborough, this display of plumage among rivals has been referred to as the patent dance, right? Which brings us to the question presented in this case. What happens if the biosimilar refuses to dance? In particular, what happens if the biosimilar refuses to provide its application and manufacturing data to the reference sponsor? How can the sponsor know which patents it needs to assert against the biosimilar applicant? Well, good thing for Justice Thomas and a unanimous Supreme Court, here's the court's answer, right? First, you can't get an affirmative injunction mandating the disclosure of that left-out application or its manufacturing data. This rests on the intersection of two statutes. The first, 35 U.S.C. Section 271E4, which limits the availability of injunctions for artificial acts of infringement, and 42 U.S.C. Section 262L9C, of course, which allows sponsors to bring declaratory judgment actions for infringement suits in such cases. Crazy enough, state law junctions for an anti-competitive business practice may be available to require the disclosure of this information. That issue is actually on remand right now, but no federal injunctions in this case, so says the Supreme Court. The second issue before the court, or the second holding of the Supreme Court here, was that the biosimilar can provide what's known as a notice of marketing even prior to the FDA giving approval. This would trigger a declaratory judgment suit under 42 U.S.C. Section 262L8A. In either case, if the biosimilar fails to comply, the sponsor has an avenue to bring a declaratory judgment suit and thereby obtain the manufacturing information and the application through discovery that it could not otherwise have obtained by an injunction. So where does this leave us, right? First, merits on the interpretation of the statute aside, I want to laud the Supreme Court's decision for clarity in an inordinately difficult area of law. Second, it establishes the BPCIA as a form of double dare with Mark Summers, right? How does a biosimilar launch its product? Well, it has a choice. It could do so either by answering trivia questions, that is, providing its application and manufacturing data to the reference sponsor, or taking the physical challenge of a declaratory judgment suit, right? That's Sandoz in 4 minutes.
Jake, do you think that branded firms got the deal that they thought they were getting when they negotiated this bill in front of Congress? In other words, they expected to have 6 months before their competitors launched in order to get their suits together and to file. They expected also to get that's not implicated directly in the case, they expected 12 years of marketing exclusivity, perhaps from the date of the statute, and they're getting it from their earlier dates of grant, which means they're often expired. How's this received? Though it's tricky in biotech because there's not the very stiff brand generic divide like in the small molecule world. Everybody's sort of doing the same things. What do you think of that?
Yeah, so I mean, I think obviously that they're upset at the idea that biosimilars can provide this notice that they're going to go to sell their product, the notice of intent, prior to essentially the FDA necessarily approving the biosimilar application. With that being said, frankly, I think if you talk to a bunch of GCs here, the only thing that they care about is now the rules are clear, right? Now we know what the battlefield looks like. And so I don't think anyone's crying in their office about, we missed the 6-month window we thought Congress was going to tell us. So there's a good scholarship from Yaniv Holet at Georgia State that actually the way the BPCAA was crafted, it was never actually designed to work. The compromise was we will write this law knowing no one is ever going to take advantage of it, and now there's actually a path forward. So I think, frankly, everyone is kind of more or less happy they at least know where the bodies are buried now.
Great. Okay, well, let's move on from an extremely complex statute to a rectangle with rounded corners. and just on the West Coast, how much our colleagues on the West Coast will give you for infringing a rectangle with rounded corners. Margot, what do you think of Samsung v. Apple?
Well, they'll give you a lot, or at least they'll try to give you a lot. So this is one of the cases in the infamous smartphone wars between Apple and Samsung. And it involved the infringement of 3 design patents. I've got those shown there on the screen. And it actually was originally the subject of a $1 billion jury verdict. Now, the verdict was for design, utility patents, and trade dress, but folks widely felt that the design patents contributed a lot to that award, which really made people sit up and take notice of design patents. in a way that they perhaps had not before. So that award was reduced to $399 million for the design patents, which is still not, chump change. That's pretty good. And that the Federal Circuit affirms that award, and the Federal Circuit affirms it based on that being the profits from all of the profits that Samsung made on the sale of those smartphones. And the Federal Circuit did that based on this statutory provision. So for design patents, we have a special disgorgement remedy that we don't have for utility patents. It's in Section 289, and it talks about being able to obtain profits when the design is applied to the article of manufacture. And the Federal Circuit said, well, the article of manufacture is a smartphone. And that's a question that went up to the Supreme Court. Is the article of manufacture the entire product, or could it be something less, a component of the product? And this was actually the first time that the Supreme Court interpreted this provision, even though it's been in the statute since the 52 Act and its predecessor since like 1877 or so. It's been around a long time, but the Supreme Court just had not had the opportunity to weigh in on that particular question. So what we had was the Supreme Court saying, well, statute involves an article of manufacture. It specifies an article of manufacture. We've got to figure out, or at least somebody has to figure out, what is that article of manufacture. So there are two steps. Identify the article of manufacture to which the infringed design has been applied, and then calculate the profits on that article of manufacture. And importantly, what the Supreme Court said was the article of manufacture does not have to be the item that is so that the design is on. It could be some component of that. And the court referenced, for example, the fact that the PTO allows for design patents to issue on components or on designs applied to components, not on a whole article. And therefore, it's certainly appropriate to interpret article of manufacture as possibly being the entire product, but possibly being some lesser component. So that was great, except unfortunately, which is not unusual for the Supreme Court, it didn't tell us how to figure out what the article of manufacture is. How do we do that first step? It ends up going back to the Federal Circuit. The Federal Circuit also doesn't want to decide that, and so the Federal Circuit sends it back to the District Court, and Judge Lucy Coe is the one who finally has to make that determination, and she does. And she looks at tests that are proposed by Apple, and she's like, oh, that has a couple of good factors, and Samsung, yeah. But the one that she likes the best and the one that she ultimately adopts is actually the test that the government had proposed to the Supreme Court. And the Supreme Court's like, no, that hasn't been properly briefed. We're not going to deal with that. And so these are actually the factors now, at least according to the Northern District of California, that used to assess what is an article of manufacture. Another reason for adopting this particular test was that both sides had, in a sense, approved of it during our oral argument at the Supreme Court and actually in the hearing at the District Court. So we now have a test, and not only that, she also identified what the particular burdens were in relation to the test, the burden that's on the plaintiff in terms of identifying that article of manufacture and the profits, and then shifting for burden of production for the defendant to basically say, no, it actually is some smaller component. And I think this is really interesting and important in that I'm not sure what impact this broadening of the possible meaning of article of manufacture is going to mean, because one of the things we've seen recently is an increase in design protection. So in the United States, we're seeing increasing numbers of design patents being granted. These are, that's from Patent.io, taking data from the USPTO. And not only that, internationally, we're seeing more design patent applications filed under the Hague Agreement. I do a lot of work at WIPO and in the Standing Committee on the Law of Trademarks, Industrial Designs and Geographical Indications. A design law treaty is being negotiated, which would also make it easier to obtain design protection in lots of different countries. And part of the impetus was the publicity and whatnot around the Apple v. Samsung decision and the kinds of money and the fact that you can get injunctive relief from this decision. So even, I'm not sure that this decision will necessarily damper the interest that we've seen, but it'll be curious to see how that plays out.
I was very skeptical of the court's interpretation of Section 289 because because the way you laid up your slide, don't worry about it, it'll take 10
Want me to
minutes
go back?
to get back there. But I mean, it just refers to the patented design. And once the patent design's on the article of manufacture, the statute goes straight to the total profit. So I found that the statute interpretation rather dubious. And I find it very difficult to predict Supreme Court cases because the stare decisis card can be played, at least in the patent space. The stare decisis card can be played whenever the court wishes. But if there's been a longstanding practice, the court just doesn't cite stare decisis and just lets it be. Still, as was discussed on the damages panel, damages, we're in a great state of hysteresis. We're having wild swings in damages law, and this was obviously, the pendulum going really, one far way. And it's going to leave a lot of work for good lawyers, I'll tell you.
Oh,
flesh out,
absolutely, absolutely. But yeah, no, I think you're right, and that's why I pointed out that in terms of justifying it, and I don't know that it's the strongest justification to point out, what the patent office is actually doing in that. Oh, there are other folks who've interpreted article of manufacture this way, but I think you make a very good point looking at the language. The statutory interpretation is somewhat suspect.
Yeah, with the Hague Convention, no maintenance fees, clever use of dotted lines.
Oh, yeah.
And design patent claims, they seem that the weak sister has come of age, that's for sure. Other comments from the panel? Okay, well, Judge, it's no secret that there's been some disarray in interpretations of the on-sale and public use bars post-AIA. I wonder if you could tell us about the Helson case.
Right, we actually have a three-judge panel that unanimously agreed on the following results in the case of Helson versus Teva. Helson had acquired an invention, the rights to an invention, on a formulation to reduce chemotherapy, inducing nausea and vomiting. And prior to the critical date, and before the FDA approval, Helson entered into a license and purchase and sale agreement with MGI. MGI was going to market the product once it received FDA approval. Helson and MGI announced the agreement prior to the critical date. They filed a press release, and MGI filed a 8K, I guess. And Helson then obtained four patents, one after the AIA and three before the AIA. When Teva initiated end of proceedings with the letter, Helson sued Teva, and the district court found as to the three patents that were pre-AIA, they were not invalid. While the purchase and supply agreement was a commercial offer for sale, it found it was a commercial offer for sale. It found that the invention was not ready for patenting before the critical date. Under the AIA, the AIA had changed the language of Section 102 and added a phrase so that it now reads, patented, an invention was patented, patent is invalid if the invention was patented, described in a permitted publication or in public use on sale, and here's the new words, or otherwise available to the public before the effective filing date. The district court found the change provides that to be invalidating, the sale must publicly disclose the invention. The sale did not publicly disclose the invention. In addition, the invention was not ready for patenting. The Federal Circuit found there was no need to address the amendment issue since the sale in this case was a public sale. So remember the language was in public use, on sale, or otherwise available to the public. Teva had argued that it was otherwise available to the public, and the court decided it didn't need to decide that one way or the other because it was available as a matter of fact to the public. And it found the existence of the sale was public because the details of the invention need not be publicly disclosed. That is, so that the one holding of the decision is that to be a public sale, the details of the invention need not be publicly disclosed. And it found that the asserted claims were subject to an invalidating contract prior to the critical date. This was a decision that followed a decision by the Federal Circuit in a case called Medicines that found that a contract was not a contract for sale. A contract with a manufacturer was not a contract for sale. But in this case, the panel found that there was an invalidating contract prior to the critical date. And it did that by looking to the law of contracts, factors such as passage of title, agreement, whether the agreement was confidential, whether it was commercially marketed, whether the defendant commercially marketed the product. There was no real dispute that the sale of the claim, as mentioned, was contingent on regulatory approval. It's still a commercial sale. And the question of whether or not the claims were ready for patenting prior to the critical date, that is, were reduced to practice before the critical date. The question is whether Helson had determined that the invention would work for its intended use, and they had. So, in essence, the decision by Judge Dyke, which passes my Galapagos test, is that the purchase and sale agreement contingent on receiving FDA approval is nevertheless a sale. So he knocked out the issue of the company patent holder waiting for the approval of FDA to confirm that it's ready for patenting. The AIA did not change the statutory meaning of sale in Section 102. And there's no need to decide the extent to which the AIA limits invalidation of sales to public sales, because the sale in this case was public itself. And the claimed inventions were also ready for patenting before the critical date. And he made that finding, the panel made that finding based on a list of series of facts about this particular transaction. The court found that the trial court was clearly erroneous in its conclusion that the patent claim invention was not ready for patenting, and it held that it was ready for patenting. So one of the arguments that was made to the Federal Circuit in the case was that this conclusion would discriminate against companies that did not have integrated manufacturing facilities and marketing facilities. But it seems like that's a policy issue that the court need not base its decision on. Because the decision turns on contract principles, it sounds like parties can contract around this ruling by the court, because it did rest on contract principles. So that's my report.
Right, so a big issue before the court, which it somewhat dodged, was addressing the status of secret prior art post-AIA. So there's the new language in the new Section 102 that says otherwise available to the public. The agency has taken, in my view, the rather remarkable construction that overturns other pre-existing case law regarding whether secret sales and public uses count. There's a fairly convoluted body of case law was saying that the secret activities by the inventor / patent applicant / patent proprietor herself would bar her patent, but otherwise third-party secret sales and uses don't qualify as prior art. So that's an issue that we thought was going to get a little bit more press in Helson, and we didn't quite get there. But I think that the Federal Circuit does seem to suggest, much like the Supreme Court, it's sticking to its own case law, and a few isolated force statements probably aren't going to turn the tide. For now, we've got a conflict between the agency and established case law, and we'll see where it goes. Thoughts on that? Good.
Yeah, I mean, this was an enormously important case to a lot of pharmaceutics manufacturers out there, because pharmaceutical composition and formulation is hard. And a lot of the companies who do this stuff actually have trade secrets. And so what you'll see often is that you'll see these large drug developers go to them to actually take a particular chemical compound they have, right, and find a way to turn that into a pharmaceutical product. And so the kind of, this case had the threat, and now since gone, of really upending a lot of the important contracts in that area. So,
Jake, you had the most difficult statute to construe and a difficult case to read, but at least it was relatively short. And we can't say that about the case that Beth was stuck with, which was already been referenced, the 135-page winner in Aqua product. And I have to say, I've not made my way through the whole thing. I'm sorry. It's just you'll find yourself wanting to do anything than try to finish it. Beth, presumably you read it. And perhaps do-
I was supposed to?
Do you have it? Yeah, that's what my students tell me all the time in class. Do you have any thoughts on Aqua products?
So yes, I'm the lucky person. I had the 135-page Judge Bryson decision on invalidity in the Allergan case, and then I have the 148-page decision here. I've had some light reading. I was laughing as I was listening to you talk. You were talking about Justice Thomas and this unanimous decision.
Oh,
You
yeah.
were lauding the Supreme Court's clarity, and I was
Yep.
going, please. I think I went down the rabbit hole, and I haven't come out yet. When you do get around to reading it, the best advice I got was to start at the end and read the dissent, and then work your way back through the decisions to come out the other end to reach your facial majority. And I actually found that to be an incredibly helpful way to sort of structure my reading, because it's highlighting different issues. So just a, totally non-academic, completely pragmatic approach to this. And you'll note I call it a facial majority. And that was the term that I've decided to go with, because just to keep things even more interesting, the judges themselves seem to have been unable to reach a decision as to exactly what the holding of the case is. I understand we're going to have some guidance on this, and that'll be terrific. Good luck with that. But there are 3 different opinions that are joined by different majorities of the judges. One of those is a dissent. One of them is the facial majority, and one of them is the infamous Part 3, okay, which is a 2-page section that was written by Judge Reyna. The key issue in the case is its interpretation of 35 U.S.C. 316E and who bears the burden of proving unpatentability of an amended claim during an IPR. Now, just briefly, I was told that there were some students here and things like that, so just to touch basics on an IPR. IPRs were created by the AIA in 2011 to provide a quick and cost-effective alternative to litigation. In an IPR, a third party can petition the director to review previously issued patent claims in an adjudicatory setting. To initiate that IPR, the petitioner has to show reasonable likelihood it would prevail with respect to at least one of the claims challenged. During an IPR, any claim can be canceled for unpatentability under 102 or 103, and it's routine for the patentee to move to amend their claims. However, patentees have rarely been successful in having their motions to amend granted by the Patent Office. In this case, Aqua Products is the owner of U.S. Patent 8273183, and the technology at issue involves automated swimming pool cleaners. Aqua Products sued Zodiac Pool Systems for infringement. Zodiac petitioned the PTAB for IPR. The board instituted the IPR, and during the IPR, Aqua Products, who had the right to file a motion to amend their claims, did so. The board denied Aqua Products' motion to amend, concluding that Aqua had failed to prove the substitute claims were patentable, that the patentee had failed to prove that their amendment was submitting patentable claims. Aqua appealed to the Federal Circuit. On appeal to the Federal Circuit, Aqua asserted the PTAB's burden-shifting interpretation of the relevant regulations was impermissible and unsupported by statute. Their primary argument was that the patentee should not bear the burden of proving the patentability of its proposed substitute claims under the plain language of 316E, which states that in an IPR, the petitioner shall have the burden of proving a proposition of unpatentability by a preponderance of the evidence. The panel decision rejected Aqua's argument, and the boards affirmed the board's rejection. Aqua sought rehearing in bank. The rehearing was held last December. The decision came down a month ago. 11 of the 12 active judges, a month ago tomorrow. 11 of the 12 active judges participated in the in-bank decision. Judge Stoll did not participate. Again, we had 5 opinions with 148 pages. The facial majority, written by Judge O'Malley, held that the burden of proof for unpatentability rests on the petitioner. However, Section 3 of Judge Reyna's opinion was also joined by 6 judges. Well, Judge O'Malley's was joined by 7, including Judge O'Malley. Judge Reyna's Part 3 was joined by 6. You need a flow chart. Okay, it was joined by 6 of the judges, And that stated that the Patent Office can impose a burden on the patent owner. And the burden is that the patent owner is under an obligation to produce evidence pertinent to the required assessment of patentability. So the patent owner is still going to have to present at least a prima facie case for patentability in its motion to amend, or risk of finding that it's failed to meet that obligation. And finally, it's also worth noting, this is just on the 3 decisions, that Judge Toronto's dissent, there's a section that's joined by 6 judges, which states that the Patent Office is authorized to promulgate a new rule regarding that burden of persuasion with respect to the patentability of proposed amended claims. You like the alliteration here, by the way? And to put that burden on the patent owner. All that that decision says is that the Patent Office can promulgate a rule, not that that rule will survive Galapagos. All right? Possibly writing for the court using a Chevron analysis, Judge O'Malley held that the final written decision of the board in the case was vacated insofar as it denied the patent owner's motion to amend the patent. The matter was remanded for the board to issue a final decision under 318, assessing the patentability of the proposed substitute claim without placing the burden of persuasion on the patent owner. So before this decision, when a patent owner proposed an amended claim in an IPR, the burden of persuasion with respect to its patentability was on the petitioner. Now, under Judge O'Malley's decision, the petitioner bears the same burden for amended claims that it has always borne for the original claims, to show by a preponderance of the evidence that the claim is unpatentable. And only time is going to tell whether that has a material change at the PTAB. On the one hand, requiring the patentee to prove patentability may have played a large role in the board's denial of the vast majority of motions to amend. As the Aqua Court notes, as of April 30th, 2016, the board had completely denied 112 of 118 motions to amend. It may have played a role. So if that burden has played a role, then the shifting of the burden to the petitioner may find the PTAB granting more motions to amend the claims. On the other hand, regardless of who has the burden, the key evidence remains the same. The written words of your prior art, the patent being challenged, and so the board's evaluation of that evidence may remain the same regardless of who has to produce the evidence and who's the first one to hand it to them. It'll be interesting to see what the Patent Office does.
Beth, I'm going to ask you this question because the judge for whom you clerked, Paul Michel, has retired. As you know, the Federal Circuit is a tribunal that seems often subject to a tongue lashing by higher powers. And what are the optics of this opinion? The unity of the court and how they would look toward this, how the Supreme Court would view this decision.
So one of the interesting things on the optics is that after Aqua came down, in a 1-paragraph in-bank order, the Federal Circuit has, in fact, they vacated another decision in Prolitech versus Centair Tech and remanded to allow claim amendments. The case raises the same issues as Aqua, and they've held off on it. But this is the court's way of saying, despite all of these different opinions and despite our disagreement, we have a decision, and this is the decision we're going to stick with. So that's one way of looking at those optics, is that, we all now regard it as the law, and it is the binding precedent of the court.
So my students know that the case I hate to teach the most is the Ariad Eli Lilly case, because I never will understand written description for originally filed claims. But if there's one person in the room who can handle it, it's going to be Jake, who has volunteered to discuss Amgen v. Sanofi.
Sure. I love teaching the Ariad case. Anyway, all right, so let me talk about Amgen versus Sanofi. It's another case about patents covering biologics. Before I do so, a brief plea. Amgen is a frequent litigant. That shouldn't be a surprise. It's the second case I'm talking about, or Amgen is one of the parties. Analysts joke that it's a law firm with a biotech company attached to it. As a consequence, it's hard, even for people like me, to keep track of which Amgen cases are which. So I'd like to propose to this august crowd that Amgen patent cases are simply renamed according to their technology. So I will refer to this, rather than Amgen versus Sanofi, as the anti-PCSK9 case, which I think is much simpler. PCSK9 is a protein that interferes with the body's own process of removing bad cholesterol from the bloodstream, more scientifically named low-density lipoprotein cholesterol, or LDL-C. This was discovered roughly 30 years ago when clinicians discovered that one of their otherwise healthy patients, a physical trainer of all professions, had a cholesterol rating of, get this, absolutely 0, right? Destroy PCSK9, the thinking goes, and the body could do what it does best. That's eat cheesecake without guilt or consequence. Since the 1970s, biologists have had tools to target individual proteins among the body's soup of tens of thousands of them, monoclonal antibodies. And indeed, monoclonal antibodies are the workhorse of the biologic drug repertoire today. 6 of the top 10 selling drugs in the United States last year were monoclonal antibodies or components thereof, if you want to get really technical. Monoclonal antibodies are inordinately complex molecules. My favorite comparison comes from the work of Nicholson, Price, and R.D. Rye. If the aspirin molecule is a bicycle, monoclonal antibodies are F-15 fighter jets, right? This presents enormous challenges to patent doctrine because patentees often cannot claim monoclonal antibodies chemically, both because they frequently don't know what the precise chemical configuration of their invention is, but also if they do so, they're enormously easy to work around precisely because they are so complex. For the past 40 years or so, patentees have claimed them more or less functionally, that is, what the antibodies bind to and where, more than what the antibodies are in a structural sense. This, in some senses, just literally violates Section 112, which requires complete descriptions of inventions, but the CCPA and the Federal Circuit have historically acquiesced to the difficulties in this science. But the science has advanced, and so has the Federal Circuit's skepticism on the virtues of functional claiming practices, so much so that there lived in name and in spirit something called the antibody exception in the corners of patent doctrines, actually a couple of them, which brings us to the anti-PCSK9 case. So Amgen develops its anti-PCSK9 product, a drug called Repatha, Sanofi, its own, a drug called Praluent. After a bench trial before Judge Robinson and Dedel, which Amgen lost, Amgen appealed to the Federal Circuit. And there, the Federal Circuit remanded for a new trial on questions surrounding written description and also enablement, for that matter. In particular, the Federal Circuit fortified its prior case law in validating antibody patents for claiming an unexplicated chemical genus rather than a specific species of compound, right? Antibodies are this attempt to claim a genus of things rather than a species, and because you can't describe them well, no patent for you. Patentees had tried getting around this by chemically characterizing not the antibodies themselves, but the things that the antibodies bound to, which is called the antigen, under the reasoning that by defining the key, you're defining the lock. But the Federal Circuit countered that this, quote, newly characterized antigen claiming practice was rather like disclosing a key and then claiming millions of locks, following on the heels of a bunch of tortured decisions of precedent that in some cases concluded things directly opposite to one another, Enzo Biochem allowing the practice, and Noel and Centocor Orthobiotech not. In Amgen's case here, its claims contain limitations to the composition itself, the effect of the antibody on PCSK9, the chemical structure of PCSK9, and precisely where on PCSK9 the antibody bound to. This is very, very much like the vast majority of antibody patents currently in force today. Despite this, and taking the Federal Circuit's reasoning at face value, it is unlikely Amgen's claims are going to survive review on remand following the Federal Circuit's decision on the 112 issue. For that reason, I think this is one of the most economically significant cases to come out of the Federal Circuit this year, if not decades. It has the power to destroy, in a real, measurable sense, billions of dollars of value. And aside from its retrospective impact, it has significant prospective ones. What are applicants supposed to do now? The only real hope are further scientific investigations of antibodies themselves, typically through things called protein crystallography studies, which are costly, lengthy, and very, very difficult. The other option, obviously, is biological deposit, which I think is problematic in its own right, especially considering the role that biosimilars play in this process. At the same time, it seems like the Federal Circuit got things right on a doctrinal level, right? Section 112 requires a complete written description of inventions, and functional limitations have to be limited to structure under Section 112F or Section 112, paragraph 6, if you prefer the older version of the statute. Upholding an antibody exception to these strictures, the wisdom of doing so notwithstanding, really presents this line-drawing problem that I think no one could logically solve. So that is the anti-PCSK9 case.
So Jake, what's the best response? Is it optical characterization, product by process claims, regulatory exclusivities, or do we have a new kind of plant patent for uncharacterizable subject matter?
Yeah, I mean, this is really something where I think the optimal method of dealing with it is just statute, right? You know, we should just have 112 paragraph G, you know, for a claim to a monoclonal antibody, blah, 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 right? I mean, I think that's one solution there. All of the other solutions are kind of, for the most part, poor responses to this only because it would allow biosimilar applicants to easily evade these things. Despite the fact that monoclonal antibodies are difficult to characterize, there's many different ways to produce the same thing. And so it's unlikely you're ever going to get a product by process patent that's really going to cover everything that you want it to cover. You're going to need lots of claims. Anyway.
Your solution seems a bit tricky under TRIPS, but of course the Europeans have their biotech directive and are getting away with it too. Let's move hastily along, and Margot's going to tell us whether one's the loneliest number.
All right, so the next case, Life Technologies v. Promega. This also involves cross-border issues in patent law like the impressions products case, but a different subsection of 271. So the product at issue here is a toolkit for genetic testing that is comprised of 5 components. And 4 of the components and the kit as a whole were manufactured in the United Kingdom. One of the components was shipped to the United Kingdom from the United States. Okay, so we don't have what we would consider to be direct infringement taking place in the United States. And in fact, Life Technologies licensed the patent from Promega, but for specific applications. And actually, the picture I have up there, it was used by law enforcement. So the relationship between the parties sours. Promega sues Life Tech for infringement, but Promega has a problem, and the problem is 271. We've got 271F and F1 and 271F2. And the problem is to come under 271F, 271F says the person has to be supplying all or a substantial portion of the components from the United States, and Life Tech is supplying one, which doesn't seem to facially fit into F1. And the problem with F2, which does allow a single component, any component of a patented invention, not if it's a staple article of commerce. And in this case, that component, Taq polymerase, is a staple article of commerce. So Promega's on the horns of a dilemma. What do? In rides the Federal Circuit to the rescue, and the Federal Circuit says, well, a single component can be a substantial portion of the components qualitatively. So Federal Circuit looks at F1 and instead of a quantitative reading, gives it a qualitative reading and says, yes, this is infringement under 271 F1. Goes to the Supreme Court, a unanimous Supreme Court reverses. And the Supreme Court does like to tell the Federal Circuit when it's engaged in what it considers to be erroneous statutory construction, even though it has its own creative statutory construction sometimes. But this, reading this, it reminded me of Carrico v. Novo Nordisk and Microsoft v. AT&T, where the Supreme Court's like, you just didn't read that statute correctly. So that's what the court basically says, that it's true that substantial can be ambiguous in the abstract, but in the context of the statute and looking at the structure, the words, it clearly has a quantitative meaning, and it means at least more than one. Okay, so one is not going to be a substantial portion of the components, and we get out of this really a bright line rule here that one is the loneliest number. It doesn't work for 271 F1. And I think that actually is the correct decision here. If you think about it, what the patentee is trying to do, if they had a UK patent, they would have been fine. Their UK patent was expired, so they get very creative in trying to interpret 271F to fit the particular facts of their case. Supreme Court's not going along with it.
Margot, I'll give you a quantitative assessment for 271F1. The imported Taq polymerase was represented over 90% of the value of the kit. All right, so maybe it's just one component, but it's the most valuable part. And that's quantitative. That's not someone's subjective impression. So one can never be substantial.
One can never, right, in terms of the number of components. And I think what the court also did, actually, in the beginning of the decision, talk about the global stream of commerce. And do you really want to allow someone who's selling a staple article of commerce to be prevented from doing that? And that they also looked at the history of 271F, and that's not what Congress was trying to get at. So, I mean, yes. And that was, I think, the reasoning of the Federal Circuit. And the Supreme Court's like, no, as a matter of statutory interpretation, we're reading this quantitatively. You look at the other words, it seems to have a quantitative meaning, and it's a numerical quantitative meaning.
I would have been more impressed with the reasoning if the court had invoked what it usually does, which is a presumption of against extraterritorial application of U.S. patent laws. But it doesn't do so in the opinion. It's straight up statutory construction. Well, there are probably two questions on each of your minds right now. The first is, will this panel delay us to the cocktail hour? And that remains to be seen. But we do have a Supreme Court ruling on what happens if you delay over much in filing your patent suit. And Judge, can you tell us about SCA Hygiene?
SCA Hygiene versus First Quality. This is a laches defense case. We have a statute that says, except as otherwise provided, there no recovery shall be had for any infringement committed more than 6 years prior to the filing of a complaint or counterclaim. And the question was whether or not that 6-year limitations period bars claims the defense of laches for those 6 years. And the U.S. Supreme Court, in a decision a couple of years ago in the Petrilla case, copyright case, held that the 3-year statute of limitations on copyrights bars the defense of laches for damages suffered during that 3-year period. So this issue came up under 286 in the patent context of the Federal Circuit. Federal Circuit split en banc and ended up finding that the 6-year period was not barred did not bar defense of laches. The Supreme Court reversed 8-1. Well, I guess 7-1, because I think Gorsuch didn't participate. And it found that the 6-year limitation on damages represents Congress' judgment that the patentee may recover damages for any infringement committed in the 6 years of filing of the claim, and rejects the argument that the 1952 statute establishing the patent laws or other defenses had preserved laches. And so laches is no longer a defense to a claim for damages brought within 6 years prior to the filing of the complaint. And I guess the point is, it's under my Galapagos theory, it's not that the Supreme Court had decided this issue before, as it had done in the Heartlands case, but it gave a pretty strong indication with Petrilla that it was going to go that way. There's lots of discussion back and forth between the majority and the minority, the dissent, in the Federal Circuit about what the law had been about venue, and I think there's some compelling arguments that venue had survived the adoption of the statute of limitations. But the Supreme Court ignored that, and they pushed around the same cases in both the opinion and the majority opinion and the dissenting opinion by Justice Breyer. But after they pushed around the cases back and forth, I think they just came to the conclusion that, look, this is a rule we set out in Petrilla, and it's going to apply here. And it sounds like it's a rule that provides for deference to Congress, but really what it is a rule that provides deference to Congress in the context of what the Supreme Court says the effect is of establishing a statute of limitations. That is, if Congress wants to set a statute of limitations, they're going to do away with any case law that would support a claim for latches.
So latches seems to be out of the picture, at least for the 6 years, at least a modest incremental advance for patent proprietors. This is going to be our last case to discuss on the panel, and Beth, it's yours. I love telling my students about the covered business method transitional program, and I have to explain to them why it's not codified. So if you could tell us more about the proceeding and what happened in secure access with PNC, that would be great.
Well, I mean, as far as it's being uncodified, my understanding, and if I'm wrong, is that it's uncodified because it's a temporary provision, which means it'll sunset out in September 2020 if Congress doesn't do something about that, which I don't think is going to happen. Last case we're talking about is secure access versus PNC Bank. In this case, we're dealing with the interpretation of 18D1 of the AIA, which is CBMs. And the Federal Circuit held that covered business method review can only be used for patents that actually claim financial products or services. They went and read the claims, and they said the claims did not mention financial products. Mind you, Secure Access had sued over 50 financial businesses who were using the product. The product was primarily, solely, probably only used in financial industries. But the language of the claims did not specifically refer to the financial aspects of this product. And they found that covered business method review can only be used for patents that actually claim the language says financial services or products. Many are saying, well, that sunset provision, we don't need to wait 3 years, it's done. Certainly, CBMs have been incredibly narrowed by this decision.
Could you, for the sake of the students, why do we have CBMs and why do people think they're advantageous to use?
So covered business method review was introduced by the AIA to give a defendant accused of infringing a patent that had at least one claim related to financial services or transactions a fast and streamlined means to challenge the validity of the patent. They've become much more important in the wake of Alice and Bilski, and they're an essential part of looking at this guidance because they're one way of having a 101 review in a post-grant scenario. For patents that were issued in the time period about which Congress was particularly concerned, which was the late 90s to the early 2000s, the CBM review is the only means of raising a 101 challenge at the PTAB. And without CBM review, the district court provides your only forum for a subject matter eligibility challenge. And there's a concern that perhaps for a patent that's not as strong, having a less expensive, faster method makes sense. They are overwhelmingly favorable towards challengers. I think something like only 4 CBM instituted petitions have resulted in no changes to the patent.
Got it. So now they've been limited. Okay,
They've been
well,
limited further.
great. Well, sadly, our time is limited as well. And let me draw to a, so yeah, first, let's thank our panel. Thank you very much. All right, so this is the most important thing that's going to be said all day. Where is the cocktail reception? Okay, yeah, in the past, we've had it in the faculty lounge, which I think all academics associate as a venue where poor decisions are made. So that will be at the Hotong Lounge, I think, with a few students around, but it's a more handsome venue. So it's going to be what, just, you know, I guess we'll go downstairs.
I'll turn around and yell, how's that? So you're gonna take the elevator downstairs to the ground floor, and when you come out of the elevator, take a right, there'll be signs pointing you. You're gonna get to go outside for a minute. It's 80 degrees outside for those of you who want to
Woo!
go there. So enjoy a nice walk across the quad to the Hotong building, and there are signs there to where the bar is.
Okay, so it's just the big glass building to the right, okay? It'll be clear enough for you. First, I'd like to thank, before you get up, just one moment, I want to thank each of you for coming. We can't do a conference if nobody attends. I'm grateful to see many familiar faces. If it's your first one, please join us. We're doing it every year. I thank a lot of our speakers. Many of them traveled pretty long distances to be here. And I really enjoyed each of our panels very much. And I'd like to thank our partners at Berkeley, in particular Peter Manel, for all the collaboration, which I enjoy very much. And I would most of all now like to thank our sponsors. Again, law schools are only as strong as their friends. Without the participation of our sponsors, we can't hold this event. And it's a really special day for me during the year. And I think it offers unique advantages, and I'm really grateful to Cisco, Google, Intel, Samsung, and Verizon for continuing to support us. Okay, so we'll take any questions about the cases or any, et cetera, with a bottle, a glass of somewhat reasonable Chardonnay in your hand of the sort you've had in law school. And again, a round of applause for our sponsors. Thank you.
Thank you. That was good. Thank you, Judge. Very nice meeting you.
Absolutely.
Who's coming down for a glass of food?